Bom dia. Sejam todos muito bem-vindos. A Escola da Magistratura do Estado do Rio de Janeiro, sob a direção geral do excelentíssimo senhor desembargador André Gustavo Correia de Andrade, cumpre seu papel de promover o intercâmbio acadêmico e fomentar o debate qualificado, desta vez com o tema Class Action and Probity, pela expertise do professor doutor Stefaan Voet, que, em parceria com os debatedores deste seminário, nos proporcionará o estudo da prática dos processos coletivos em uma visão europeia, complementar, contraposta, tangencial, comparativa à realidade brasileira. Esta é a terceira reunião do Fórum Permanente de Transparência e Probidade Administrativa da EMERJ, que tem por presidente a excelentíssima senhora desembargadora Inês da Trindade Chaves de Mello, que coordena o seminário Ações Coletivas e Probidade Administrativa, em conjunto com as professoras doutoras Lúcia Frota Pestana de Aguiar e Larissa Claire Postman da Silva. Para darmos início ao evento, convidamos a compor a mesa diretiva a excelentíssima senhora desembargadora Inês da Trindade Chaves de Mello, presidente do Fórum Permanente de Transparência e Probidade Administrativa da EMERJ. Nosso palestrante convidado, o professor doutor Stefaan Voet. Excelentíssimo senhor promotor de justiça, professor Humberto Dalla, membro do Fórum Permanente de Transparência e Probidade Administrativa da EMERJ, que será o debatedor desta manhã. Professor doutor Rafael Iório, vice-reitor da pós-graduação, pesquisa e extensão da Universidade Estácio de Sá. A professora doutora Larissa Claire Postman da Silva, advogada, pós-doutoranda em Direito Processual pela UERJ. E a professora doutora Lúcia Frota Pestana de Aguiar, membro do Fórum Permanente de Hermenêutica e Decisão da EMERJ e secretária-geral da nossa escola. Cumprimentamos a todos os presentes, desejando 2 dias produtivos de evento. Com a palavra, a excelentíssima senhora desembargadora Inês da Trindade Chaves de Mello.
Bom dia a todos. Hoje é um dia muito especial para a Escola da Magistratura, porque nós estamos recebendo um jurista internacional de escola, o professor Stefaan Voet, que falará sobre as ações coletivas na União Europeia, e os nossos debatedores farão uma comparação com as nossas ações coletivas aqui no Brasil, né? Isto é fruto de um trabalho que a EMERJ tem feito justamente para internacionalizar, né, e trazer para todos os estudantes, todos os profissionais de direito, a possibilidade de ter contato com outros direitos, outras culturas, e ter um intercâmbio muito produtivo para o nosso desenvolvimento profissional e também para aprimorar nossa pesquisa. Eu também tenho que agradecer, além da presença do professor Stefaan Voet, que inclusive chegou hoje de madrugada e está aqui prontinho para nos transmitir seus conhecimentos o dia inteiro. Muito obrigado, professor, pela sua colaboração, pela sua disposição, boa vontade de estar aqui para compartilhar o seu conhecimento conosco. Também tenho que agradecer a presença do professor Rafael Iório, que fará a abertura oficial do evento, né, vice-reitor-geral da Universidade Estácio de Sá, que também está tendo um belo programa de internacionalização, né? Inclusive eu fui a Mercer com a Universidade Estácio de Sá, e irei esse ano a Burgos. Eles estão fazendo um trabalho maravilhoso nessa área. Agradeço a sua presença, professor. Também agradeço a presença do professor e membro do Ministério Público, Humberto Dalla, que também é meu professor no doutorado da Estácio, e que vai ser o debatedor e será o responsável pelo direito comparado hoje aqui na nossa palestra. Ele nem se tocou da responsabilidade. Grave, né? Grave. Agradecer também a participação, a colaboração da professora e da doutora Larissa também, que foi ela que nos convidou para montarmos esse evento. E sem a participação e a colaboração dela não seria possível, né? E a nossa quase DIN, né? A nossa quase reitora, secretária-geral Lúcia Frota, que também muito se disponibilizou para que esse evento seja feito e tenha o melhor aproveitamento possível para todos vocês. Muito obrigada.
Passamos a palavra para a saudação à professora doutora Lúcia Frota Pestana de Aguiar.
Bom dia a todos. Eu quero agradecer inicialmente a desembargadora Inês pelo convite a participar desse primoroso evento, a mesa toda, professor Rafael Iório, que também é presidente de um Fórum de Culturas Jurídicas, vice-presidente do Fórum de Culturas Jurídicas Comparadas, junto com a doutora Fernanda Duarte. Quero agradecer também ao professor Humberto Dalla, professora Larissa, e especialmente ao nosso convidado internacional, o professor Stefaan, que é uma gentileza de pessoa, que já estava, inclusive, nos aguardando nessa impontualidade crônica que o carioca tem tido por causa dos trânsitos, né, da nossa cidade. E agradecendo, já pedindo desculpas a ele por essa circunstância. Mas, especialmente, hoje, eu gostaria de agradecer à desembargadora Inês por estar realmente encampando o projeto do nosso diretor-geral, nosso querido desembargador André Gustavo Corrêa de Andrade, que iniciou essa gestão com a proposta de internacionalização da Escola da Magistratura. Uma proposta inovadora que ele vem implementando com a ajuda dos presidentes de fóruns permanentes. E hoje a desembargadora Inês está nos brindando com essa palestra especialíssima do professor Stefaan e com professores tão qualificados aqui compondo na qualidade de debatedores. Então, é uma honra imensa fazer parte aqui desse momento e brindá-los com assim, o nosso agradecimento especial e nossas boas-vindas para o professor Stefaan. Muito obrigada e uma ótima palestra a todos.
Ouviremos agora a professora doutora Larissa Clar Postman da Silva.
Bom dia a todos. Gostaria de começar cumprimentando a mesa dos presentes, agradecendo a desembargadora Inês, que prontamente acolheu a ideia, a proposta palestra, a Lúcia também, que também encampou o projeto e fez ele acontecer. A gente está aqui hoje. Agradecer ao professor Stefaan por ter vindo e aos professores Rafael Iório e Humberto Dalla por terem prontamente aceito o convite, aceitado participar, e a gente está realizando esse evento hoje. Desde já, gostaria de desejar a todos uma boa palestra e encerrando já as palavras para a gente poder ouvir os nossos convidados e nos brindando com tanto conhecimento aqui nesse dia de hoje.
Neste momento, ouviremos a abertura oficial, o professor doutor Rafael Iório.
Bom dia a todos e todas. É um prazer enorme estar aqui participando desse evento Class Actions and Probity. Eu gostaria muito de agradecer o convite feito pela excelentíssima desembargadora doutora Inês Trindade, cumprimentar aqui a todos os membros da mesa, professora Lúcia, professora Larissa, professor Humberto e professor Stefaan. dizer que para nós é uma honra participar e e me coube aqui poucas palavras e vou ser muito breve nessa abertura, mas de falar de duas questões que são bastante importantes num evento como esse. Primeiro, esse é um evento que retrata todo realmente, como a professora Lúcia colocou, o esforço que a Escola da Magistratura vem tendo nos processos de internacionalização e de afirmação da sua produção de pesquisa, então, com a criação e ampliação dos fóruns. Então, aqui também me sinto na figura de vice-presidente do Fórum de Culturas Jurídicas Comparadas, e também do esforço de ampliação da internacionalização da escola e da parceria entre a universidade que eu represento e a Escola da Magistratura, ou seja, o quanto nós podemos ganhar com os processos de internacionalização. Esses processos de internacionalização nos permitem, basicamente, duas questões. A primeira ampliarmos fortemente o fator de impacto das instituições envolvidas dentro desse processo. Então, nós costumamos dizer, e eu sou um aficionado pelo estudo dos processos de internacionalização das universidades, né? Como representante institucional, participo de eventos como a FAUBAI, NAFSA, etc., que são associações internacionais pelo mundo que discutem os processos de internacionalização das universidades. Então, o que a gente sempre aprende no estudo desses processos é que essas relações são sempre relações de ganha-ganha. Ou seja, é uma relação em que, mesmo que estejamos lidando com uma universidade que tem um maior fator de impacto que a universidade que nós estamos nos relacionando, essa universidade também ganhará dentro desse processo de internacionalização. Por quê? Porque conseguimos aqui aprender as diferenças, conseguimos aqui ampliar parcerias para a produção acadêmica, realizar mobilidade de alunos, ouvir pesquisadores de outros países, ou seja, nos enriquecemos sempre, não há perdedores nessas relações internacionais. Então, fico muito feliz de participar de um evento desse que estimula esse tipo de relação. E, por fim, o segundo ponto, que toda vez me cabe agora como vice-presidente do Fórum de Culturas Jurídicas Comparadas, é de lembrar a todos que toda vez que nós estamos estudando, né, direito comparado ou realizando comparações, sempre importante aqui a percepção das comparações por diferença, aplicação do método da comparação por diferença, porque quando eu aprendo o que o outro sistema realiza, quando eu vejo o que o outro faz e me comparo com ele, eu me conheço melhor, crio capacidade, estofo crítico para compreender melhor o meu sistema. Então, se eu aprendo o que são as class actions em determinado país da Europa, por exemplo, ou nos Estados Unidos, e vejo qual é o comportamento desses institutos, como é que a doutrina está aqui articulada, como a jurisprudência se posiciona, como eu traduzo categorias. Às vezes nós temos um problema de tradução de categorias, né? Ou seja, podemos traduzir as class actions mesmo, é só uma pergunta assim, por ações coletivas, é isso mesmo? Ok? Faz sentido dentro da cultura jurídica brasileira esse tipo de percepção? Então, estudos como esse permitem que a gente conheça melhor, no final das contas, o próprio sistema jurídico brasileiro. Então, com isso eu encerro e agradeço novamente muitíssimo o convite e me sinto muito honrado de estar ao lado aqui do professor Stefaan e aprender aqui com ele. Tá? Muito obrigado e um bom dia a todos e todas.
Ele é doutor em Direito pela Universidade de Ghent, com o Prêmio Trianual de Processo Civil concedido pela Allgemeine Modellen Versammlung voor de Rechtspraktijk. Et là, je vous demande pardon parce que c'est vraiment compliqué le nom. Professor associado na Universidade de Louvain, Bélgica. Professor convidado na Universidade de Hassel. Membro do Centro de Estudos Sociojurídicos da Universidade de Oxford. Membro da Rede de Processo Coletivo compostas pelas universidades de Stanford, Oxford e Tilburg. E associado do Laboratório de Processos Coletivos de l'Université de Montréal. Com a palavra, para a palestra Ações Coletivas na União Europeia, o professor doutor Stefaan Voet.
Thank you very much. Can you hear me? Yes, okay. Ladies and gentlemen, good morning. I first of all have to apologize because I am the only person in the room who does not speak Portuguese. I know 3 words of Portuguese, and I think they can take me quite far. I can say bom dias, I can say obrigado, and I can say caipirinha. And I think that will take me very far. It's my pleasure to be back here. I was here in December last year for 2 weeks. And first of all, you also have to apologize if my English is not excellent, because as already was mentioned, I arrived this morning at 4 o'clock after a flight of 15 hours. So if my brain does a little bit strange, then my apologies for that. I was here in December last year, and Larissa invited me together with Professor Aloisio Mendes. And I had a wonderful time here. I lost a part of my heart in this beautiful, beautiful city. And I think it's very laudable, also the previous event, but also this event, to focus on comparative international law. As my colleague Professor Iorio already mentioned, I think it is very important to look at each other's system, not in particular to find out how that system works, to find out to learn about the details, the nitty-gritty details about other systems, about procedural vehicles that exist in other systems, but mainly to look at these systems, first of all, to better understand your own system, and secondly, to learn from that. So I think that it's the first time that I have noticed that a country that is so far away from Europe is paying so much attention to this. So I think this is very, very important. And I really would like to thank all of the people around this table and the organizers of this event for having me. So, muito obrigado. Now, as you have seen on the program, there are 3 different panels, and in those 3 different panels, I will say something. But these 3 different things are all interconnected, and they basically, a large part of the things that I will say are in this book, and I will donate this book to the school after the conference. It's a book, Delivering Collective Redress, New Technologies, that I have written together with a colleague from the University of Oxford last year. And it goes back to a conference that we organized in December 2016. And I think, Larissa, you were there at that event, I think in Oxford in December 2016. And what we basically did in the book and also in the conference was looking at how European jurisdictions are trying to resolve mass harm situations. If there is a collective problem, if a collectivity of people is being harmed by the same or similar legal facts or issues, how are jurisdictions dealing with this? And in the book, we've listed a number of techniques, a number of tools that are being used to resolve that. And during my interventions at this event, I will talk about these different tools. But what I will first of all do in the first part, in this first panel, is I will speak about class actions in Europe. And with the term class actions, I mean, we in Europe mean representative actions. So somebody, an association or an individual or a governmental body that goes to court and that acts on behalf of a large group of people that are not quantifiable, that you also cannot identify, and that representative is claiming on behalf of that collectivity of people. And the outcome of that procedure is binding on all of these people, although they are not party to the proceedings. They are bound by the res judicata effect of that decision. This is something new in Europe. I've noticed in other countries, especially in the common law countries, the US, Canada, Australia, it is something that already exists for many, many decades. Also in Brazil, there's been a long tradition of class actions, but class actions in Europe is something completely new. And I will briefly speak about this. Now, you all know that there is something that is called, that is called the European Union. It is in the news, I think, almost every day for the reason that one of these member states, the UK, wants to leave the European Union, which I think, and history will show this, is a very unwise decision. But I think that is one of the reasons why it's in the news all the time. But the European Union goes back to the, and I will not give you a historical overview, but goes back to the end of the Second World War, where international organizations were created in Europe, and that ultimately led to the European Union. That European Union does a lot of things, and one of the things it does, it attributes substantive rights to citizens and companies, and it tries to harmonize those rights. And what you can see on this slide is just an example regarding consumer rights. We are all consumers. Every day we buy things. If something is wrong with the thing, then we have certain substantive rights. We buy a television, the television breaks down. We have an agreement with the bank, and the bank overcharges, and you have to pay costs to the bank that are unlawful. You buy a coffee machine, and the coffee machine explodes. You buy a ticket to take the plane, and there is a delay. All of these things are examples of consumer mass harm situations, and the European Union has harmonized all of these substantive rights and has given rights to European consumers. Now, giving rights is one thing. The other problem is you have to enforce these rights. If something goes wrong, then you have to enforce these rights. And on the slide, you can see a number of examples of cases that have popped up in Europe the last couple of years. For example, there are a lot of cases against airlines regarding planes that are delayed. The breast implant case that has had an impact, I think, all over the world. I think also in Brazil, I think there also has been litigation about this case. The Volkswagen case is exactly the same. Cases against banks. The Lernout and Hospi case, I'm showing this on the slide because probably this afternoon or tomorrow I will talk about this case, because it's a case that deals with fraud and that also deals with the way how the government, the public prosecutor, has dealt with this collective case. I will talk about this case later. So these are a number of cases that have arisen the last couple of years. And there are three basic questions that one has to answer. First of all, what is the problem? Two, what are the solutions? And three, do the solutions work? The first issue is, what is the problem? I think this is very clear. You have a collectivity of people that are being confronted with the same or similar facts or legal issues and that want a resolution for their problem. And it doesn't make sense if all of these people, first of all, it doesn't make sense if all of these individuals, if all of these victims individually go to court. It absolutely does not make sense. And secondly, in a lot of these cases, the threshold to go to court to undertake action is very low. For example, if you have a company that sells, and it's one of the cases of a couple of years ago, a company, for example, I don't know if you have that in Brazil, when you have a phone, a cell phone, you could buy a card that gives you credit. For example, it costed 10 euros or 15 euros. Well, there was a case where a company sold these cards, and instead of 15 euros, the card contained 13 euros. So you pay 2 euros too much. Okay? Nobody that has brains will go to court to sue for 2 euros. But on the other hand, if that company has sold 1,000 or 10,000 of these cards, then the company, of course, has made a lot of money, and all of these people are the victim of that. If you add all of these little damages, if you all calculate them together, then it's a large amount of money. And then the question rises, not how to compensate those people, but how can you take away the illegal profit that the company has made? So these are the problems. Secondly, what are the solutions? And I will talk about the solutions. And finally, do these solutions work? What are the solutions? And in the book, we have discovered that in Europe, to date, 3 different solutions are being used. First of all, and I will talk about this one first, we call this collective redress. You will see in my lecture and also in all of the policy documents of the European legislator, they almost never speak about class actions. The reason is that class actions are immediately being associated with American class actions. And American class actions in Europe are being regarded as a bad thing, because the lawyers make too much money and there is too much frivolous litigation and it's very dangerous and it costs a lot of money and it is not efficient. And for marketing reasons, and this is true, this is not a joke, I once had a talk many years ago with somebody from the European Commission, and I said to this lady, I said, "You're speaking about class actions." Yeah, we speak about class actions. And I was asking, why don't you use the word class actions? Why do you speak about collective redress all the time? And then she looked at me and she said, the marketing people said it was a bad idea to speak about class actions. We have to speak about collective redress. So this is the reason why the term collective redress is being used. There are also 2 other techniques: consumer dispute resolution, which is a variation on ADR, and the second thing, and this is something new, this is something controversial also, it is called regulatory redress. It is redress offered by public bodies. It's public enforcement plus redress. But I will not speak about this now, I will speak about this later. First of all, class actions. As I mentioned at the beginning of my talk, class actions originated, basically they originated in English law, and then English law moved to the US. And in the US, this class action vehicle was basically developed. And the American class action system, of course, is the system when you look at class action law internationally. That is, of course, the point of reference. But something is going on with these class actions in the US, in the sense that the doors that give you access to class actions, especially in federal courts, just like in Brazil and US, they have federal courts and state courts. In Europe, we don't have that. We don't have that distinction between federal court and state courts. We have federal countries. Belgium, my country, is a federal country. It is so big, it's very small. We were talking about this before that. You have in Rio 10 million people, 11 million people. In one city, in whole Belgium, we have 11 million people. So all my country lives in the city. There are 2 states. These states have a lot of competences, but we don't have state courts. We only have federal courts. But in the US, you have federal courts and state courts, like in Brazil, and you can bring class actions in state courts and in federal courts. In federal courts, it has become more and more difficult to bring class actions. There have been a number of Supreme Court decisions that are making it more difficult to bring these cases in federal courts. First of all, the certification criteria have been interpreted very strictly. There has been a trend towards arbitration, towards class arbitration, etc. And you see on the slide there a number of leading class action scholars who have written about that. So in US, something is going on with these class actions. It's more difficult to bring them. In Europe, you see another trend. In Europe, you see, oh, there's this thing called class actions. Oh, it looks very interesting. And already in 2007, which is a long time ago, more than 10 years ago, Ton Hartlief, who's a very famous professor in the Netherlands who teaches civil law, said that it is clear that resolving mass cases must be prioritized and that possible obstacles in the law must be cleared out, even when they have their foundation in important principles. It is clear that there is dynamism in this part of the law. And then, over the course of the years, you have seen a number of studies. European institutions love to publish studies. It costs a lot of money. Academics can make a lot of money with that, but they don't do a lot of things with these reports. And you see, over the number of years, there have been a lot of policy papers, green papers, consultation papers, public consultation papers, resolutions of the European Parliament that basically say, okay, this class action vehicle, it's very interesting and we should think about that and maybe we should do this, but there are also some dangers, blah, blah, blah. But the bottom line is we should try and focus on these things and maybe we should try and find out whether they could work in Europe. Now, an important study, and I don't know if there are people in the room that are doing research about that, but if you really want to know something about dispute resolution in Europe in general, how we try to resolve these disputes, I would like to refer to the first report of 2006. It's already a bit outdated, but it is still a very good report, not because it was made by some colleagues of mine of the University of Leuven, but what that report contains is basically an overview of all of the existing mechanisms that exist today to resolve disputes. And it contains what is called a dispute resolution continuum. And you see, and during my talk now, and also this afternoon and tomorrow, I will refer to this dispute resolution continuum a couple of times. Now, in 2013, the European Commission issued a recommendation. Now, first of all, it's important, I will mention some instruments of the European legislature. And for this audience, I think it's important first to briefly describe this. A recommendation is just a recommendation from the European Commission to the 27 now member states. And it's a recommendation. You don't have to follow this. It's not binding, but we really please would kindly ask you to take into account this recommendation and implement it in national legislation. A directive, and I will speak about the directive later, a directive is binding. A directive is an instrument from the European Parliament and the European Council that sets out a number of goals that the member states have to achieve. How the member states achieve that goal is up to them. But you have to achieve the goal. I will give you an example regarding something completely different, but it explains how it works. For example, some people smoke. I'm not a big fan of smoking, and now when you buy a package of cigarettes, I don't know if this is the case in Brazil, it says on the cigarette packet, smoking kills, or it contains some disturbing images, okay? There was a European directive stating, okay, there has to be a deterrent effect that when you publish something on that cigarette packages, that makes people scared of smoking. That is the goal. How the member states implement it, it's up to them. Some countries have used words, other countries have used pictures, but how they implement it is up to them. But the directive states you have to achieve that goal. If the country does not achieve that goal and does not implement the directive into national legislation, then the European Commission can sue the country before the Court of Justice of the European Union, and the country can be convicted to pay a fine because they did not implement the directive or they did not implement the directive on time. A third instrument is a regulation. And a regulation is directly applicable in all the member states. So a regulation does not have to be implemented in the national member states. That is immediately and directly applicable. So that recommendation, non-binding instrument of 2013, with a very long name, Common Principles for Injunctive and Compensatory Collective Redress Mechanisms in the Member States Concerning Violations of Rights Granted under Union Law. So it focuses on injunctive collective redress and compensatory collective redress. An injunction, you go to court and you ask the court, please issue an order so that the company stops doing something wrong. Compensatory collective redress, the court says to the company, you have to pay back everybody that suffered damages. The distinction between injunctions, injunctive collective redress, and compensatory collective redress is important for the rest of my story. So please keep that in mind, because I will come back to that in a moment. But the recommendation focuses on two. So in all of these instruments, injunctive collective redress and compensatory collective redress, they go hand in hand. Now, the biggest issue of these European-style class actions is the fear that it would lead to frivolous litigation, that you would have lawyers making money with these cases, and that the money, the compensation, does not go back to the victims, okay? And they always look at the system in the US, and they say the US class actions are an example of abusive litigation, which is not true. There is no hard empirical evidence in the US that class actions are by definition frivolous or not a good thing. There are, of course, some excesses, and there has been a lot of legislation to improve that, but I think that is a false statement. But in Europe, we said, okay, we don't want these abusive class actions, so if we will have European-style class actions, we want safeguards. We want a lot of safeguards. And some people have said there are too many safeguards. And if you have too many safeguards, you create a catch-22 situation. You kill the system. You want to have a class action, but you have so many safeguards that the safeguards basically are destroying the instrument. Now, what are these safeguards? And this is important because the focus of this conference is also a little bit on public enforcement and public policies. This is important. And I think this is a big difference with Brazil. European class actions cannot supplement public enforcement. You know, most of you know that in the US these class actions are not only being used to obtain compensation, but they are also being used to change the policy of the government. The civil rights movement in the 60s of the previous century in the US gave rise to the use of these class actions. In the 60s, class actions were used in the US, for example, to end segregation, to end discrimination, to give rights to colored people. It was the perfect tool to change the policies, okay? Later, these class actions were also used, sometimes abused, to claim compensation. In Europe, there's a very big wall between public enforcement and private enforcement. Class actions can only be used for injunctions to stop companies doing something wrong or for compensation. They cannot supplement public enforcement. So if a company does something wrong, for example, they pollute the river. I remember here in Brazil a couple of months ago, there was another, I think, environmental disaster. I think a company did something wrong and a lot of waste or something came in a river and polluted the environment. In Europe, first the public bodies, the public prosecutor, regulators, public bodies, they will first act and they will first do their investigation. Competition law, if companies violate rules of competition law, the national competition agencies will first do their investigation. You cannot bring a private class action for compensation as long as the public process has not ended. You have to wait. You have to wait. And in a lot of these cases, when the public process finishes and the public body comes to the conclusion that a company did something wrong, then you can use the decision of the public body to go to court and to claim compensation. But as long as the public process has not ended, you have to wait. And the idea is that private class actions cannot supplement public enforcement. Recital 6 of the recommendation, it is a core task of public enforcement to prevent and to punish the violations of rights granted under union law. The possibility for private persons to pursue claims based on violations of such rights supplements public enforcement. The directive on antitrust damages actions, compliance with the EU competition rules is ensured through strong public enforcement of these rules by the Commission. The European Commission also plays an important role in competition law, and the NCAs, which are the national competition agencies, in combination with private enforcement by national. So first important safeguard, a strict division between public enforcement and private enforcement. Secondly, the European legislator says, okay, you European country, you can have these class actions, but what we basically want you to do is to try and settle these cases out of court. So there is a lot of focus on out of court collective redress, collective settlements. And I will speak about the Netherlands in a second, and the Netherlands has a system in which they only, but it has changed recently, in which they have what are called class action, only class action settlements. Member states should ensure that the parties to a dispute in a mass harm situation are encouraged to settle the dispute about compensation consensually or out of court, both at the pre-trial stage and during civil trial. What are the main features of these European class actions? And I will not, of course, go into the details. I just want to highlight the most important features. First of all, these class actions are what are called and it's a very difficult word, of a transubstantive nature, or what is called a universal nature, in the sense that you should have these class actions in all fields of law where the European Union gives rights to citizens and companies. Consumer protection, competition, environmental protection, protection of personal data, financial services legislation, and investor protection. So they should have a universal scope. Second point, and this is a very big distinction with the US, and I don't know in Brazil, I think in Brazil this is also possible, but the people around the table are more experts than I am. Individuals cannot bring class actions. Individuals do not have standing to bring a class action. Only associations, organizations, and also public bodies, certain public bodies, can bring a class action. And the idea is to avoid abusive litigation. If it's true or false, this is another discussion, but for example, it is in all of these policy papers, it is stated that in the US, class actions have to be brought by individuals, but these individuals have no idea what the case is about. The case is so complicated, so it's basically the lawyer who is bringing the case. And it is said that the individual for the class action lawyer in the US is the key to the door of the class action court. And it leads to abuses. In Europe, no individuals, only associations, organizations, public bodies can bring a class action. There's a very strict certification phase. So in the sense that what the court first of all will do is verify whether the class action instrument is the most appropriate instrument to resolve the case. There has to be commonality, there has to be typicality, adequacy of representation, etc. So the court will first rule on the admissibility of the class action. Only when the class action is admissible, only then the court will look at the merits of the case. So there's a very strict distinction between the certification phase and the phase on the merits of the case. Regarding opt-in, opt-out, the opt-in means that all of the class members have to come forward and have to say, yes, we will be bound by the res judicata effect of the decision. They do not become parties. They only say, we will be bound by the res judicata effect. Opt-out is the other way around. An opt-out system is where you have individual class members who are saying, okay, we do not want to be bound by the res judicata effect. If you do not opt out, you will be bound. In the US and in most common law jurisdictions, most of these class actions are of an opt-out nature. In Europe, there has been a very strong tendency to oppose opt-out class actions. The idea that somebody who is a class member and that person will be bound by a judicial decision in which he is no party is completely crazy, some people say. Especially German scholars. German scholars are very traditional, very conservative, and a lot of German scholars say, you cannot have that. You cannot have an individual who is bound by a judicial decision in which that individual was not a party to the procedure. You cannot have that. So for a very long time, opt-out class actions were opposed, and they said you can only have opt-in class actions. But the tide has changed. The tide has changed. And now more and more European countries are allowing opt-out class actions, and also the European recommendation states that you can have these opt-out class actions. Funding and financing, which is, for me, I think the most important issue of this class action vehicle. If you don't have an appropriate system on how to fund and finance this kind of litigation, then it doesn't work. It's a very complicated issue, it's a very complicated topic in the sense that funding and financing class actions boils down to what is called an investment asymmetry. In the sense that you have, and you can see this on this slide, you have class actions. One of the most important features of a class actions is that it has what is called a triangular structure. If you have individual litigation, it's very easy. You have one plaintiff and you have one defendant. It's one-on-one litigation. I buy a house, there is something wrong with the house, I sue the person who sold me the house. So there's the buyer and there is the seller. There's the consumer and there is the trader. Two parties, very easy. In class action litigation, it's more complicated. The two parties that are before the court are the class representative and the class counsel, and also the defendant. On the plaintiff side, there are three parties. There is the class representative who represents the class, but the members of the class are no party to the proceedings. And there is also the class counsel. So on the plaintiff side, you have this very complicated structure. And this has an influence on how you fund and finance this litigation. Because as I explained in the beginning of my talk, you bring these class actions on behalf of people, but you don't know who these people are. You don't know how many people there are. You don't know their names. So you cannot ask these people to pre-finance the litigation. Like in a one-on-one litigation, if I will sue the person who sold me the house, well, I will have to pay my lawyer, I will have to pay the court fees, I will have to pay, for example, other costs that, for example, if the court appoints an expert, I will have to pay this because it's my case, it are my rights that are being adjudicated. In class action litigation, this is not the case. It's the rights of the people of the class who are being adjudicated, but these people are not a party to the proceedings. So you cannot ask them to pre-finance the litigation. And what you see then is more and more there is... It makes it very complicated to fund and finance this litigation, and what you see is that there are a lot of techniques that are now being used to finance this litigation. One of the techniques that has come to the fore is what is called third-party litigation funding, where you have banks, insurance companies that fund and finance that litigation. Second point, who can bring that class action? This is something that I have explained previously. An individual class member, but this is in the European context not allowed. Governmental bodies, associations, and foundations. I will go a little bit quicker. That recommendation was evaluated in 2018, and the conclusion was threefold. There were three conclusions that were made. First of all, the European Commission came to the conclusion that these principles are good, and we have to promote these principles. But the second thing is, and I told you that recommendation is a non-binding instrument. So the member states do not have to implement it. And in that evaluation report, it was stated that we should have an instrument that is binding. And the lady who you can see on the slide is Vera Jourova. She was the Commissioner for Consumer Affairs. A couple of days ago, the European Commission proposed the new commissioner. She will remain a commissioner, but not for Europe, but not for consumer affairs. And she basically said that we should have a binding instrument regarding collective redress. And in April 2018, the European Commission issued what was called the New Deal for Consumers. And that New Deal for Consumers wants to strengthen the rights of consumers. And I was speaking about substantive law, substantive rights that are being given to consumers, and they want to enforce that. But what they also want to do now is to create an instrument that is binding. And in the beginning of my talk, I gave you I spoke about the recommendation, a directive, and a regulation. In 2009, the European legislator issued what was called an Injunctions Directive. And that Injunctions Directive stated that the member states, all of the member states, should designate what are called qualified entities, consumer associations, public bodies, that should have the possibility to bring injunctive class actions. So a consumer association sees that a company is violating the law, that consumer association should have the possibility to go to court and ask the court to issue an order in which the court says that company has to stop doing something wrong. Injunctive collective redress, that was created in 2009. And that instrument functions pretty well. The problem with these injunctions is, first of all, the people who suffer the damages, the people who suffer the harm, they are not party to those proceedings, so they are not bound by that decision. And secondly, they are not being compensated because they are only injunctive orders. The court does not have the possibility to order the company to pay back all the people who suffered damages. So this is the framework that was created in 2009. And what you see now in Europe, and that was the proposal of that commissioner, is we will keep that system, but we will add another layer. And those entities that, based on the 2009 Injunctions Directive, had the possibility to bring injunctive class actions, now also should have the possibility of bringing compensatory class actions. So it's basically the same framework, but adding another layer. That proposal was approved by the European Parliament in the spring of 2019. Now it still has to be approved by the European Council. Of course, in all of the different members, this is basically what is happening on the European level. In the various European jurisdictions, you see that more and more of these countries are having class actions. You can see there an overview. And of course, each national model is different. And a lot of things have to do, ladies and gentlemen, with legal culture, okay? Brazil is a very big country, but the legal culture, I think, is everywhere the same. In Europe, you have 27, 28 different countries, but the way how they look at law is completely different. In Scandinavian countries, they don't like courts. They don't like to go to courts, and a lot of these cases are being settled outside of the courts. They have class actions in Scandinavia, but do they have a lot of cases before the courts? No. Finland, very cold in Finland. In Finland they have class actions. You know how many cases, class action cases, were brought in Finland? 0. Nada. No cases. We don't like courts. We will not go to court. Sweden, Denmark, Norway, exactly the same. Denmark has a very interesting system, but I will come back to that later, okay? So it has to do with legal culture. In countries, for example, like Belgium, France, and Germany, the focus has been on associations. You cannot have individuals bringing these class actions. It has to be associations. So it's very difficult to create a unified model. 2 examples, but I will only speak about the Belgian example, is that since 2014, Belgium has experimented with these class actions. And I think from a constitutional point of view, this is a very important point. In 2014, the Belgian legislature created class actions, but only to deal with consumer disputes. And one of the issues, one of the questions that was thrown on the table when the law was proposed was, okay, and I was one of the people who was questioning that. I said, okay, you can have class actions in consumer law cases in Belgium, but you do not have class actions, for example, in environmental cases and in competition law cases. And I think that was my idea, together with a number of colleagues. We said this is a constitutional problem. It's a discrimination, a constitutional discrimination. In Belgium, we have a constitutional court, and a constitutional court said this is not a problem. But I still think this is, and it goes back to the point I made in the beginning, that the European legislator basically wants you to have class actions that are of a universal, transubstantive nature, so that apply in all kinds of sectors. And again, and this will follow up later. I don't know if it's, yeah, this will follow up later. So the conclusion of my talk is, okay, we have these class actions. There's some initiative on the European level. In a number of member states, we also have these class actions. But the question is, are a lot of cases being brought? We have class actions in Belgium since 2014, 15, 16, 17, 18, 19, 5 years ago. How many cases were brought? 6 or 7. In the Netherlands, they have class action since 2005. How many cases have been brought? 7. France, big country, has class action since 2014. How many cases have been brought? 15, 16, 17. So there is the possibility of bringing these cases, but when you look at what is going on the ground and in practice, you see that the instrument sometimes is not being used. And the cases, ladies and gentlemen, are not the most fascinating cases. I will just give you one example. It's a very funny example. It's one of the class actions that was being brought in Belgium. It was a case against Groupon. Groupon are vouchers you can buy, okay? And it was a voucher that parents could buy to buy a box of diapers. When you have a baby, the baby cannot go to the restroom, the baby needs a diaper. So when you have a baby, you need to buy diapers. So that voucher allowed you to receive every month a big box with 30 or 50 diapers. You had to pay 30 euros, and then every month you received the big box with a number of diapers. So people paid 30 euros a month, and sometimes they did not receive a box of diapers, or there were not enough of diapers in the box. In total, 3,000 people made a complaint and said it said that we were going to receive 50 diapers, we only received 45, something like that. So this was a class action that was being brought. So you see that the cases that are being brought based on that instrument, they're not the most fascinating cases. This is an overview of the Dutch cases. The Dutch system is interesting in the sense, but it has changed since the beginning of this year. In the Netherlands, you can only you first need to have a collective settlement. So what happens in the Netherlands if there is a collective problem, you have an association. That association sees there's a problem. A company did something wrong. A company violated the law. That association cannot bring a class action. That association first has to speak to the company and has to try and have a collective settlement. If there is no settlement, the case ends. The only possibility then for the individuals is to go individually to the court. Since the beginning of this year, this has changed because the Netherlands has changed its law. If you have a collective settlement, then you can go to the court and you can ask the court to approve, to homologate that collective settlement. And you see here on the slide the number of cases that has been brought. What is very interesting, but it would take me too far to explain this, are competition cases. A lot of these competition cases originated in the US. In the US, a company violates rules of competition law, and then a competition class action is being brought in the US. For decades, non-US class members were able to join the American class action. A number of years ago, the US Supreme Court issued a decision, the Morrison decision, and in the Morrison decision, the US Supreme Court said you can bring these US competition class actions, but only on behalf of people who bought stock on an American exchange market. People who bought stock somewhere else, non-US class members, cannot join the class action in the US. Big problem. Big problem. Because these big companies wanted to settle these cases, and they did not only want to settle the cases with the Americans, they also wanted to settle the cases with all the class members, also those who are not American. So since the Morrison decision, there was a problem, and these American lawyers, they looked on the world map and they said, oh, there's this little country in Europe, the Netherlands, where they have settlement-only class actions. So what they did, and all of these cases, Shell, Converium, Dexia, are all examples of that, are global, worldwide cases in which first they bring a class action in the US. On behalf of the US class members, they have a class action settlement in the US that is being approved by the court. And what they then do, then they go to the Netherlands, they establish a foundation, an association in the Netherlands, they have the same settlement with the same company, and then on behalf of all non-US class members, they go to the Dutch court and ask the approval of the settlement for the non-US class members. And what is very interesting, these are the same lawyers. And in one of these cases, and you can see this in the Shell case and in the Converium case, the American lawyers asked the Dutch court to approve their fees. And everybody in Europe, most scholars said, the Dutch court will never do this. The Dutch court did this. And then, for example, in the Shell case and in the Converium case, the Dutch court approved, for example, in the Shell case, the American lawyers who were acting in the Netherlands asked 50 million of attorney's fees, and the Dutch court said, okay, no problem, we will approve this. And the reasoning of the Dutch court was, if there is no collective settlement on behalf of the non-US class members, then these people cannot go everywhere, cannot go anywhere, because there is no other jurisdiction where they can go. If, for example, in the Converium case were started in the US with a class action on behalf of the US class members. But in the Converium case, there were also a lot of people from Switzerland who suffered damages. And these Swiss class members could not go to the US because of the Morrison decision. So the American lawyers set up a foundation in the Netherlands on behalf of almost 2,000 Swiss class members. There were only 200 people from the Netherlands. And everybody thought the Dutch court will say, we don't have jurisdiction. You have a Dutch court that is being confronted with a collective settlement with almost 2,000 people from Switzerland. What is the connection with the Netherlands? Nothing. The Dutch court approved the settlement. And the idea was there is no alternative for these Swiss class members. Because if we don't approve the settlement, who will take care of their rights? The only possibility they will have is to sue individually. So the bottom line is, we have these class actions in the European Union, more and more. It's the consequence now of a specific policy. But when you look at it from an empirical point of view, not a lot of cases are being brought. And the reason is that there are other techniques that are being used. But about these other techniques, I will speak this afternoon and tomorrow. So I will finish my talk for this part. So, obrigado.